The audio that stopped a trial. Cold. What you're about to hear isn't what they want you focusing on. A microphone no one noticed, a conversation never meant to exist, and a judge who ended an entire trial without raising his voice. Judge Caldwell didn't shout. He didn't bang the gavel. He did something far more unsettling. He went completely quiet. Then, without warning, he ordered U.S. Marshals to seize the defense's laptop right in front of the jury, right in front of the cameras, and right in front of attorneys who suddenly looked like their entire careers had just collapsed in real time. So what was on that laptop? What was captured on that recording? And why has everyone involved gone silent? I've watched the footage 17 times. Every replay reveals another detail most people miss. And once you see what pushed Judge Caldwell to that moment, everything starts to make sense. It came down to one sentence, one decision, one line the defense should never have crossed. During a routine recess, a microphone that should have gone dead stayed active, and it picked up a conversation between the lead defense attorney and someone who should never have been speaking to them at all. But here's the key detail most reports leave out. This wasn't random. This wasn't bad luck. This was weeks of questionable behavior finally catching up, and I'm going to walk you through exactly how it all unraveled, because the case itself was already volatile. A federal fraud trial, millions on the line. Powerful names, the kind of case that makes reputations or destroys them. Judge Caldwell had been overseeing this trial for 3 months. 3 months of nonstop motions, objections, and a defense team that always seemed one step ahead. Too polished, too prepared, always ready. People noticed. Nobody could prove anything. Until the microphone stayed on, until that conversation was recorded, until Judge Caldwell heard something that made him stop everything. That moment everyone keeps talking about, it's coming. But first, you need to understand what the defense thought they were getting away with. Because once you see the full picture, you'll understand why Judge Caldwell did exactly what he did. What actually happened. Tuesday morning, 10:47 a.m., courtroom 4B of the federal courthouse. The kind of room where careers end and legacies are written. Judge Caldwell called a standard 15-minute recess. The jury filed out. Prosecutors gathered their files, and the defense team clustered at their table, voices low, confident that, like every other break, no one was listening. They were wrong. The courtroom audio system, installed for ADA compliance and official records, includes microphones throughout the room. During active sessions, only certain zones are live. During recess, the system is supposed to shut down. Supposed to. A technical failure or something else kept the defense table microphone active, and it recorded everything. The lead defense attorney spoke quietly but clearly. She changed her statement. "We've got the revised version. They don't know she spoke to us." Then another voice entered the conversation. Unidentified. Not a lawyer. Not part of the legal team. "She's nervous," the voice said. "She'll say what we told her to say. Just make sure the judge never finds out about the contact." The conversation continued. References to altered testimony, mentions of an arrangement, and then the sentence that made Judge Caldwell stop breathing for a moment. Caldwell won't know until it's too late. The audio was being monitored in the clerk's office, standard protocol. Within 60 seconds, the recording was in Judge Caldwell's chambers. He listened once, then he stood up and walked back into that courtroom. Witnesses say his expression never changed. No anger, no surprise. Just calm, controlled, terrifying. He didn't speak to the jury. He didn't acknowledge the prosecution. He looked directly at the defense table. "Mr. Harrison," he said flatly, "remain seated." The lead defense attorney started to stand, started to object. "I said remain seated." That's when the marshals moved, not toward Harrison, toward the laptop sitting open on the defense table. "Your Honor, this is outrageous," Harrison protested. "What's outrageous," Judge Caldwell interrupted, "is what I just heard on the courtroom audio feed." The courtroom froze. "The laptop is seized as evidence. All members of the defense team will surrender every electronic device immediately." The jury was rushed out. The prosecution sat frozen, stunned, and the defense team watched as their phones, tablets, and drives were placed into evidence bags right there in open court. But that wasn't the shock. Judge Caldwell wasn't finished. "This trial is suspended pending investigation. Mr. Harrison, you are ordered to remain within this jurisdiction. All defense counsel are barred from contacting the defendant, the witnesses, or each other until further notice." Harrison's face went white, not pale. White. Your Honor, our client has rights. Your client's rights are not the issue, Caldwell cut in. Your conduct is. Then came the sentence that made every lawyer in that building sit up straight. Federal marshals will escort you to processing. You are not under arrest yet, but obstruction of justice, witness tampering, and conspiracy charges are under review as we speak. The courtroom went silent because everyone understood what had just happened. A sitting federal judge had caught defense attorneys allegedly coordinating testimony on tape in his own courtroom, and he had responded with the legal equivalent of a nuclear strike. If you're watching this thinking, finally, someone's telling the whole story, you're not alone, because what happened next split the legal world straight down the middle. Within hours, defense advocacy groups were calling it a nightmare scenario. The National Association of Criminal Defense Lawyers released a statement almost immediately. Seizing privileged attorney-client materials without a warrant sets a terrifying precedent. According to them, Judge Caldwell didn't act on law, he acted on instinct. One civil liberties attorney put it bluntly. A judge heard a private conversation he didn't like and immediately confiscated property. What happened to the Fourth Amendment? What happened to attorney-client privilege? And suddenly the narrative cracked open. Social media exploded. Half the internet crowned Judge Caldwell a hero. The other half called him a tyrant in a robe. Legal Twitter turned into a war zone for 48 straight hours. And here's the uncomfortable truth no one wants to admit. They weren't crazy questions. Was the recording even legal? That microphone wasn't supposed to be live during recess. If the audio shouldn't exist, can it be used? Did Judge Caldwell actually have authority to seize that laptop without a warrant? Legal experts are genuinely divided. And then there's the biggest unknown of all, that second voice. Who was it? If it wasn't a witness, if it wasn't part of the defense team, then what exactly did Judge Caldwell hear? What if it wasn't witness tampering at all? What if it was misunderstood language? What if an innocent defense team just had their entire case and careers destroyed in under 2 minutes? One critic on cable news didn't hold back. Judges don't get to become prosecutors. Caldwell heard something, assumed the worst, and acted as judge, jury, and executioner. That's not justice. That's vigilantism with a gavel. So who's right? A brave judge who stopped corruption in real time, or a man who let suspicion override procedure? That's the question no one wants to answer. And the deeper you dig, the messier it gets. The warning signs. Everyone missed. This didn't come out of nowhere. Weeks before the courtroom exploded, the red flags were everywhere. It started with one witness, Maria Delgado, a former accountant for the defendant, scheduled to testify about falsified financial records. Her original deposition was devastating, precise, detailed, impossible to explain away. Then everything changed. 3 weeks before trial, Delgado's attorney contacted prosecutors with a revised statement. Suddenly, the numbers were uncertain. The documents she'd verified were possibly misremembered. Her once rock-solid testimony collapsed into doubt. The prosecution flagged it immediately. They raised concerns with Judge Caldwell. "Something feels wrong," the lead prosecutor later said in a filing, "but we couldn't prove anything." And that mattered. Suspicion isn't evidence. The defense was entitled to benefit of the doubt. Judge Caldwell's hands were tied. But everyone noticed. The defense's cross-examinations were too perfect. Their objections anticipated prosecution moves before they happened. Their witness preparation bordered on supernatural. Every week, they seemed to know what was coming. Caldwell reportedly told his clerk, "Something isn't right. I can feel it, but I can't act on feelings." Until he didn't have to. That microphone gave him what he'd been waiting for. Evidence. Recorded evidence. Evidence that didn't require interpretation. The defense had been pushing their luck for months. They had no idea one technical failure, one microphone left active, would be the trap that ended everything. What no one realized in the moment. While everyone was focused on the public seizure, they missed something critical. During that 15-minute recess, Judge Caldwell had already made a call. After hearing the recording, he contacted the U.S. Attorney's Office directly. By the time the laptop was being bagged, federal investigators were already on their way. This wasn't a snap decision. This wasn't emotion. It was execution. Caldwell ensured the audio was preserved with proper chain of custody. He prepared legal justification under the crime fraud exception. He coordinated with federal prosecutors before stepping back into the courtroom. The seizure wasn't the beginning. It was the reveal, a trap months in the making, and the defense walked straight into it. The legal world holds its breath. Former prosecutors are calling it unprecedented. In 20 years, one said, I've never seen a sitting judge move this fast on suspected witness tampering. Judges are cautious by nature. Caldwell moved like someone who already knew. And that's the part that's haunting legal analysts. The crime fraud exception is real. If attorney-client communication furthers ongoing criminal activity, privilege disappears. If Caldwell is right, everything on those devices is fair game. Even defense attorneys are quietly admitting it. I defend the accused for a living, one said. But if that recording is accurate, that wasn't defense work. That was obstruction. The real question? Did Caldwell have enough in that moment? Was the recording definitive proof or language that could be explained away? This will be litigated for years. Every piece of evidence pulled from those devices will be challenged, and Judge Caldwell knows it. He didn't just bet on a ruling. He bet his entire legacy. If he's right, he's a hero. If he's wrong, he may have destroyed his career and handed a guilty defendant a free pass. And then the defense made it worse instead of staying silent. Instead of letting lawyers handle it, Harrison stepped in front of cameras on the courthouse steps. Judge Caldwell has engaged in judicial tyranny, he declared. Our constitutional rights have been violated. We will take this to the Supreme Court. Legal analysts were stunned. Attacking a judge publicly while under investigation for witness tampering? One commentator said it best. That's like pouring gasoline on a fire while standing in it. And things escalated fast. Supporters of the defendant flooded the courthouse. Online threats surfaced. Judge Caldwell's home address was leaked. The U.S. Marshals Service assigned him protection. His family was moved to a secure location. And Judge Caldwell? He hasn't said a word. Not one. Which tells you exactly who's still in control. The questions that won't go away. Why was that microphone still active? The system had been installed for 12 years. This had never happened before. Who was the unidentified voice? Why did Maria Delgado's testimony shift exactly 3 weeks before trial? Sources say forensic analysis of the seized devices is uncovering significant irregularities. The FBI's Public Corruption Unit has taken the lead. That's not normal. That suggests something bigger, something political, something powerful. And now, here's where it gets chilling. The full recording is reportedly over 6 minutes long. Only fragments have been referenced publicly. Judge Caldwell has moved to seal the entire audio, citing sensitivity to national investigations. National. That word doesn't get used casually. Where things stand now, the trial remains suspended. The defendant is in custody. Bail revoked. Harrison and 2 defense attorneys have been suspended pending bar review. Their law firm has gone dark. Devices remain in FBI custody. And Judge Caldwell is under 24-hour protection. On the surface, it looks like a judge who caught corruption and paid the price. But I've learned this the hard way. Stories like this never end clean. There are whispers the glitch wasn't accidental. Rumors Caldwell was warned before trial. And one detail no one can explain. That unidentified voice. Voice analysis allegedly links it to someone inside federal law enforcement. Not a witness, not an outsider, someone on the inside. So ask yourself, is this a story about justice or a trap within a trap with players we haven't even identified yet? I don't know the answer, but I know this. Whatever happens next is going to be bigger than anyone expects. And the only question left is, will you be watching when it does? This trial is suspended pending investigation. Mr. Harrison, you are ordered to remain within this jurisdiction. All defense counsel are barred from contacting the defendant, the witnesses, or each other until further notice. Harrison's face went white, not pale. White. Your Honor, our client has rights. Your client's rights are not the issue, Caldwell cut in. Your conduct is. Then came the sentence that made every lawyer in that building sit up straight. Federal marshals will escort you to processing. You are not under arrest yet, but obstruction of justice, Witness tampering and conspiracy charges are under review as we speak. The courtroom went silent because everyone understood what had just happened. A sitting federal judge had caught defense attorneys allegedly coordinating testimony on tape in his own courtroom, and he had responded with the legal equivalent of a nuclear strike.